thank you so much for joining this issue briefing. My name is Jaime Ho, editor of the Straits Times from Singapore. To everyone here, thanks again, and to the people sort of watching the stream, thank you very much as well. The title for today's issue briefing is called "See You in Court, the Rising Tide of Climate Litigation." Before I introduce the panelists, let me just get a little bit of a definitional issue out of the way in defining what we're talking about in terms of climate litigation. I would say that climate litigation is broadly defined as legal action brought before administrative, judicial, and other investigative bodies in domestic and international courts and organizations that raise issues of law or fact regarding the science of climate change and climate mitigation and adaptation efforts. And so to discuss this with us today, and I'm told that this is one of the first few times this issue has been discussed by the forum here at the annual meeting, so exciting times. With us, the panelists, I'll start first with Alice Garton. She's Director of Strategy at FILE, which is the Foundation for International Law for the Environment. Ms. Ayisha Siddiqa, she's a co-founder of Fossil Free University and Polluters Out. She's also a fellow at NYU Law's Climate Litigation Accelerator. And Sebastian Vos, he's the chair of Global Public Policy Practice and head of European Division, Covington and Burling LLP. Thank you so much for being here. Maybe I'll start off with Alice. I mean, as I said, it's one of the first few times we're discussing this at the forum. So give us a sort of a state of play, lay of the land, in terms of where we are at in terms of climate litigation. I'm told in the last 2 years, at least, almost as many as 500 cases out there. But for us, just give us a lay of the land.
Thank you, Jamie. Is this adequate? Yes. So there's actually more than 2,000 cases now. It's been increasing rapidly. Still, predominantly, most of those are brought in the US, UK, Europe, and Australia. But the numbers are increasing across Latin America, Asia, and the Caribbean. Also, we now have 13 cases across Africa. This is published in the LSE Litigation Trends Report in 2022, and each year they publish a report on the state of climate litigation. At its highest level, the cases are about three things. The first is around where a particular project is creating harm to a local community or indigenous groups, and also will have a broader harm on climate change through greenhouse gas emissions. The cases are brought by those local communities, represented by public interest law firms regularly, and they win where the science and the law permits it. These cases also look to create the framework for increasing access to clean energy in those communities. So from 2020, over 800 million people lacked access to electricity across Asia and Africa. So we need laws and to create better frameworks to enable that access. It needs to be clean and just energy, not fueled by fossil fuels. The second category of cases relates to that as well. So it's against governments, and it's at the government framework level, and really looks at what are the laws that those governments have signed up to? Are they complying with them? What are the rights of the citizens to bring cases against them to accelerate their ambition? There are over 70 of those cases globally, and we've had some notable successes in the Netherlands, UK, Germany, Brazil, and South Korea. The third category, particularly relevant to WEF members, of course the first two are also relevant to doing business, is against corporates. The vast majority of those cases are against carbon majors, but we are seeing cases against other sectors as well. The first category, again, it's called a framework case because it looks at the business model of the company, and plaintiffs are going to court and asking where the business model itself is likely to create significant harms to people in the future. The court will intervene and set boundaries on how they operate. It won't get into the day-to-day business operations of the company. That's not the court's job. The most notable is the Shell, Mille-de-France and Shell case. The second category is seeking compensation or damages. These primarily arise in the US, but again, just recently we've seen these sorts of cases, most notably RWE and Swiss company, Holcim, concrete company. And the final category is greenwashing. So, in short, the highest, the project and government cases are about 70%, companies are about 30%, but we're seeing a change in the numbers with an increase of cases against corporates. Current win rate is about 50%, which is higher than most sort of commonly accepted basis of claim and certainly higher than a lot of criminal case rates. In terms of who's bringing them, I'm going to leave Ayisha to talk more about that, but it's impacted communities and those least responsible for harms. But we're also seeing a huge range of other claimants. So because climate change is now a pervasive issue and also a financial risk, we're seeing cases, shareholders against directors, so Client Earth against the board of Shell. We're seeing consumer cases, a whole range. I will, in terms of just future trends, last comment, Jamie. Regrettably, I don't see the numbers going down. I only see them going up. And that's a great shame because it means that more harm has ensued and therefore more people have been justified in bringing their cases to courts. Courts are there ultimately as a pillar of democracy to remedy harm and loss and enforce laws, and they do that based on the science. The science is clear, and it has been clear for many years. This has been a foreseeable risk, and that's why we are seeing companies and governments and other actors held accountable. The final thing that I'll predict is that actually the thing that WEF members should be most concerned about is not the NGO philanthropically funded cases, but the deep-pocketed commercial litigation funded cases, which are likely to ensue because we have left the transition too long. We've known about this for over 30 years, and it's now going to be a very, very messy and complex one. So we know that these sorts of firms and their funders are watching the space and will step in, and it'll be the cases of WEF members against WEF members that are likely to be most expensive.
Thanks, Alice. Now, I'll turn the floor now to Ayisha, and you obviously speak on behalf of many vulnerable communities, and obviously there is a sense of a perceived lack of urgent action, injustice, and rights violations sometimes. So tell us then, from your perspective, why is it that climate litigation has become, as Alice has suggested, more and more of an attractive tool in the face of, as we've said, the perceived lack of action?
Mm-hmm. First, I'd like to begin by assuring that I know vulnerable communities and I represent one community, but you know, there's such an intersection and complication, and I would never want to suggest that I represent all of those vulnerabilities. On the reason why climate litigation is becoming a tool increasingly is because the international community has failed in delivering their climate promises and actions, and everyone from civil society, young people, human rights groups have said that in order to fulfill the compliance gaps, governments need to do better with their own commitments. Unfortunately, the intergovernmental process, time and time again, is non-binding. We saw an influx of climate litigation cases begin with the Paris Climate Agreement being ratified, I suppose, and prior to 2015, only 5 rights-based litigation cases were in process. After 2015, because of Paris, 40. But that is also to show that what is coming out of the intergovernmental processes from the Loss and Damage Finance Fund that is being perceived, and I suppose it is a victory to Paris, to Kyoto. We still need mechanisms to hold the promises accountable. We still need mechanisms to figure out who will deliver and who will pay for those promises. And in addition to that, litigation is the way that communities, I think, have begun to try to fill the compliance gap. I wanted to take a moment to highlight some of the cases that are both setting precedent but also giving hope. The first one being the Pakistani High Court case in 2015 that established that government delaying inaction would violate the country's and citizens' fundamental rights. This is incredibly important because when a government attributes recognizing citizens' fundamental rights in relation to climate and in relation to their human rights per the Constitution, we can see that vulnerable communities can begin holding their governments accountable even further. The other case is the 2018 Colombian Supreme Court case, which ruled in favor of young plaintiffs who sued their government and to hold it accountable at its own international climate-related pledges. And then more recent, the court landmark judgment in the Neubauer case, which specifically prompted the German government that it needed to increase its 2030 greenhouse gas emission reduction target to further increase and move up its net carbon neutrality by 2045. And from the human rights perspective to the youth perspective to vulnerable communities perspective, I think there's one thing that if we can all acknowledge, it's that having right to clean air, clean water, livable land and soil is a basic fundamental right. Unfortunately, this process is still so vague and ambiguous, and this is how communities are taken advantage of. As climate litigation develops and as these cases come in more influx, not only is it a calling to corporations to do better in their compliance, I think there is a cultural shift that what we're arguing is beyond just rhetoric. Yeah, I think on that, that is it from me.
Okay. Thanks, Ayisha. Sebastian, it's obvious from what we've said, at least so far, clearly the field of climate litigation has evolved very quickly. It's probably going to evolve even faster in coming years. You get more and more diverse range of actors, as Ayisha has alluded to, and the corpus of new law will probably grow as well. From the law firm perspective, tell us how you all are preparing for this in terms of preparing clients, in particular, about this field of climate litigation, and what is, for example, what are your sort of priorities as you start talking to corporations who should be increasingly concerned?
Great. Thank you, Jamie. And thank you also, of course, to Ayisha and Alice. My name is Sebastian Vos, and I am at a law firm, but I should say that I head our global public policy team. Those of you who are familiar with Covington will know that we're Washington, D.C. based, and we have globally around 120 former regulators and policymakers at the firm, including a number who are very well known in the area of climate and sustainability. Is that better? Yeah. Sorry about that. This includes, for example, Carol Browner, who was with the EPA for 8 years, Dan Feldman, who until recently was the Chief of Staff to John Kerry, and as of last Monday, yesterday, Andris Piebalgs, who was the EU Energy Commissioner, but also played a very big role in developing the SDGs. And so what my part of the firm, what my team does, is we try to help our clients to be ahead of the curve in a positive way. So we try to help them to develop practices and also just to shape their business in such a way that they can avoid climate litigation by being good actors. We have, as a firm, been involved with WEF for a long time, also a part of the European Green Deal, where we've worked with a number of WEF members on developing pilot projects to move that along. I hope you will understand that as someone speaking from a law firm, I have to be careful not to talk about specific clients or cases. So what I plan to talk about is some trends in litigation. I'll zoom in a bit more on the US and the EU and the differences. Why I expect there to be an increase in cases, and I think it's not only because there are more transgressions, but I think there's going to be more visibility, which is probably a good thing. And then I'll talk a little bit about how we try to help our clients. So the first thing, in the US, it's been interesting to see that on the Democrat side, there's been quite a lot of government-led action where they're going against the oil and gas sector for deceptive advertising, public nuisance, and so on. What has surprised me is the actions which you've seen on the Republican side, where there are a number of Republican officials in member states, in states, I should say, such as Texas, who are going after companies who, in the views of those in this room, are probably trying to do the right thing, but making their lives difficult. So you're seeing, in particular, and Alice and I were talking about this earlier, investment companies, financial services companies who are trying to steer their investments into sustainable areas, who are being penalized or put in a very difficult place by those regulators. So there's a bit of a delicate balancing act there, and we're of course trying to help them to steer that in the right direction. But it's led to something which I only heard about recently, which is green hushing, which is where you're actually trying to do the right thing, but you can't talk about it, because if you do, then you get in trouble in Texas. Anyway, Europe, by contrast, has been led mainly by public interest groups, civil claims. Alice mentioned a number of those in the Netherlands, among others, but also in Germany and France. We're seeing also recently some big and very important cases, which I think, for those of you with an interest in this, are definitely worth watching. Then why do I expect to see an increase, especially in Europe? I think that's because of the new EU ESG due diligence and CSRD corporate sustainability reporting rules, which are going to make it increasingly necessary for any companies who are either European headquartered or who have substantial operations in the EU, I should say, to be transparent about what they're doing and to disclose what they're doing, not only when it comes to their sustainability efforts, but also when it comes to forever chemicals, mercury, and these kinds of things. And that opens companies up to the risk of more litigation. I should say that, and this will be of interest to you guys for sure, is that the extraterritorial jurisdiction of many European systems will also mean that this CSRD impact will be felt, I think, globally. Then finally, what do we do for clients? We try to help them to understand where this is heading. We try to help them to understand their obligations, how their obligations are going to develop. We try to help them to report properly, but we also help them to identify issues that they may have in their supply chain and to help them to minimize any adverse impact that they may have either socially or environmentally. And that's it.
Thank you, Sebastian. Looks like we are making perfect time. I'm happy to open the floor now to questions as well. We have a couple of minutes for that. When you do, just say who you are and then who you are addressing the question to. If there aren't, then as moderator, I'll take the prerogative to ask more questions, but over to the audience first.
Hi, thanks for all the insights. I'm Jessica from Eco-Business in Singapore. We've seen great progress in climate litigation, but we've also seen cases like the Australian one being thrown out of the High Court. And then also energy majors like ExxonMobil suing the EU for having to pay taxes or making 20 billion of profit in a quarter. So I'd love to hear your perspective on whether you expect that pushback. And, I guess, what do you think the outlook is for climate litigation? Thank you.
Alice first, maybe you.
Yeah, it's a really good point. They're not always climate outcomes, these cases, positive climate outcomes. There are increasingly cases being brought which have negative outcomes for climate. That's what I was alluding to really about the increasing numbers and the increasing claimants and types of cases. It's because the transition will be very messy. The law is available to all. As much as I don't like the outcomes of the cases, personally, I'm not going to criticise them because it's a fundamental pillar of democracy to have access to the courts. The important thing to note is that the values by which society is operating is also changing, and people and citizens are becoming far more aware of the seriousness of this and who is most responsible. So that will percolate through to court decisions as well. But hopefully, of course, primarily it's going to be our legislators and our governments and, again, the members of WEF who are able to step up and make decisions which prevent those sort of negative climate outcomes.
Ayisha, maybe I'll get you to answer as well. From your perspective, are you also not concerned that for every force, as Jessica from the audience has suggested, for every force there will be a counter force, right? It's something that Sebastian as well alluded to. How does that factor in, do you think, to new actors who are considering actions on one side of the equation?
So litigation is interesting, and I say this as not a lawyer. but somebody who's researching it, because as cases come forth and precedents are set, it then also at times allows corporations to jump over the issue raised in a former case and find a new way to get to exploitation, to get to violation of people's rights. It's a constant additional, and that also means that those who are bringing, communities specifically, are bringing forth these claims are going to have to get more creative. That is really, now this is my opinion, I think that's really unfortunate. But it's not going to be as simple as these rights were established and they're going to be an overarching established mechanism internationally. And then the other case really is, we talk about vulnerability. And when we say vulnerability, we think of children. We think of young people. We think of Black and brown communities. We think of women. One area of vulnerability that is left out time and time again are citizens of unstable governments. Citizens where courts don't work, of states where the legal system doesn't work. So what is applied internationally cannot be applied domestically. And that, unfortunately, is also in parallel to where the climate crisis has its most dire effects. It happens to be in the global south, and the people that are facing the effects of the climate crisis happen to live in unstable governments. And that is a framework that the law cannot very easily transpire or transgress.
Sebastian, would you like to weigh in?
Well, as I mentioned, it's difficult for me to talk about specific cases,
Sure.
but I think what I can say is that, with a European policy perspective, and I don't know if some of you were able to listen this morning to the Commission President Ursula von der Leyen, it's certainly my perception, living in Brussels and working in Europe, that there is a very, very strong very strong direction of travel in policies when you look at clean tech and the net zero ambitions to move in the right direction. Because I think, the number of climate deniers in Europe, I believe the number is shrinking, but you guys will know that better than I do. And I think there's an awareness of the importance of these issues. It's very difficult to talk about, which way the courts are going to go on this. I was interested to hear from Alice this 50% win rate. I hadn't heard that before. That's definitely quite high if you look at the average for court cases. So that's an interesting statistic. But I think what's going to be very interesting is this increased pressure on delivering information on what you're actually doing, and that citizens, companies, governments can go after those who are not doing what they should be doing.
Okay. Any other questions out there? Yeah, please.
Hi, I'm Karan. I'm a global shaper, and I work with Loudest Foundation on making the fashion industry sustainable. But I have two questions, really, and maybe you can answer them as one. But one is around we're talking about climate litigation, but also looking at communities, but also what I think I'd like to understand more is the role of natural systems and how we sort of value them and how we can also ensure that we're protecting and giving rights to these natural systems in these climate sort of cases. And the second part of that is perhaps how do we also work with corporations or work through legal systems with corporations to think through ways in which we can hold them accountable to the sort of ways in which they're exploiting natural resources and make sure that they're not over-consuming or, well, leading to the climate crisis that we're in and trying to mitigate more. So those are my questions.
Okay. Ayisha, maybe take a first stab.
Sure. On your first question about how we're incorporating the rights of nature, I think where we're seeing the most creativity is coming from indigenous communities. Specifically, I'll refer to the Sarayaku case in the Ecuadorian Amazon, which the community has argued that the Amazon is a living being and it has its own rights, equivalent to as a human would have their human rights. And this genuinity, is that the right word, is allowing a lot of creativity to enter the legal field. And then the other thing I'd like to bring up is the island nations. The island nations have been pivotal in pushing not only policy and legislation, but also bringing in the creativity, which goes to the larger point where we're going to find solutions are the communities that are being most affected by climate change. And a good frame of reference for this is the 1.5 degree mark that we have kind of speak about as gospel. That emerged because at 1.5 degrees, the island nations will sink. The most interesting opinion that I think, not most interesting, an interesting opinion that is at the front of the ICJ, the International Court of Justice right now, is asking the island states, specifically Vanuatu, is asking the ICJ to write an opinion where the individuals' human rights are in relation to climate. And although this is not a legally binding document, the opinion in the framework of the ICJ will allow a great deal of movement in litigation cases, because the ICJ has written opinions about genocide before that have then allowed for communities to file for retribution and reparations. So the answer to rights of nature, rights of people, I think the answers are in indigenous communities and vulnerable communities in island states.
We're just about running out of time, so maybe what I'll do is, Alice, if you like, try your hand quickly at the second part of the question, and then concluding remarks, if you would, and then Sebastian and then Ayisha to also round off the last 5 minutes. Thanks, Alice.
First of all, I completely agree with Ayisha. The most ingenious ways that we're seeing the law involve in cases that are coming forward are coming from these communities and from island states. In terms of the application to biodiversity loss and nature, those categories of cases that I went through, as soon as we're seeing it now, but the science, the evidence becomes strong enough, the same ones can apply. So rights-based cases, we already have one against Casino in the French supermarket in relation to supply chains in deforestation, Brazil. Financial risk cases, nature washing, I suppose, instead of climate washing. So I expect the trend to continue in relation to those other categories as well. In terms of final remarks, I just wanted to come back to really the point I made that I think the narrow definition of climate litigation that we started with, it would be most helpful if we all started thinking of it in a much broader way. And it's climate litigation is litigation, and it's going to be evident throughout all parts of society brought by different members. As Ayisha said, in only certain countries this is the case, but that's the role of multinationals in particular, who have certain influence in the way they use their extractive practices in these other countries. So the answer is the same way to deal with public interest litigation as well as private interest litigation. I think the answers are the same, which is to reduce emissions rapidly, reduce your impact on biodiversity and nature, support strong regulation because it creates a level playing field and it creates those rules of the game so that the companies can then operate safely within and understand what's right and wrong, where they might be liable or not. And I suppose the number one thing is don't be defensive. I was reading the WEF report and talks about how we manage these risks, and one of them is don't be defensive looking at these trends. Actually really look at what the NGO climate litigation cases are trying to teach us all about future impacts and the way society should be operating in the future. The lessons are really there in the wins that we've seen to date. Thank you.
Thanks, Alice. Sebastian.
Thanks, Jamie. So I think I'll finish with 3 I's when it comes to climate litigation. It's incredibly innovative, as you've heard from this panel, and I think hard to know how exactly it's going to develop, but it is certainly going to develop. So number 2 would be it's important. You know, whether you're a company or a government, you need to understand where this is headed so that you can handle yourself in the right way. And the third is it's going to increase. So, you know, whether it's because there's bad behavior that has yet to be found out or because the rules get stricter, one way or the other, this is going to increase. So if you know as a company or as a government that you're doing everything right, don't worry. But my guess is there's not many governments or companies who can say that they know that for sure. So I guess my message would be go and do your homework.
Brilliant summary. Thanks. Ayisha, you have the final word.
Thank you so much, and thank you so much for those of you who are in the room. I wanted to take the time out to bring in my personal perspective because, well, I am not a lawyer, and I was invited to this space as an advocate. I began doing climate work through the lens of activism. And then over the course of the past 5 years, I'd received phone calls from my friends who ended up in jail for holding a banner. Another for standing outside of their parliament in a country where they don't have the right to freedom of speech. And as a result, you know, one thing that has dawned upon me is we look to the youth climate movement for not only hope, but for ambition, for so much, and it's something that we incredibly applaud. But where are the systems for defense of land defenders? They don't exist. This is a very well-known fact that indigenous peoples protect over 80% of the world's biodiversity and make up less than 5% of the world's population. And recently, before coming to this panel, somebody asked me, you know, how can WEF and funders and philanthropy know that they're investing in people who will solve the climate crisis? And my answer to that is, we have been protecting the earth for free for the past hundreds and hundreds of years. We are nature defending itself. I am nature defending itself. And for this reason, we are not just up against any industry, any corporation. We're up against, for every $1 we have, we're up against institutions that have hundreds of thousands. For every one lawyer we have, we're up against institutions that have hundreds. We need to not only uphold the law and also create policies that will save our planet, we need to support the people that are working on this in the front lines. And there is a huge lack. This goes back to my point of human rights. It is incredibly unfortunate that the violence that is endured by people asking for clean water, clean air, and a right to a livable planet is so immense in the world. My last sentence is indigenous people's survival, Black and brown communities' survival, the global South's survival is nature's survival. It is the developed world survival. It is economy survival in totality. Thank you.
Ayisha, touching words. Thank you so much. Alice and Sebastian as well. We made perfect time. Thank you. I had a whole list of follow-up questions, but obviously I wish we could continue, but we can't. To all of you, thank you as well for staying with us. Thanks.